Appeals, Division 1 is now in session.
Please be seated. Morning, Council. Court now calls case number CV150744, McNally versus Sun Lakes. This is the time set for oral argument. Council, you probably were in here before when I was sort of giving this litany, but you have 20 minutes to present your oral argument. Counsel for appellant, and that is Mr. Chaifetz. Mr. Chaifetz, you can reserve some time if you want for your rebuttal. You don't have to stand. I want both of you to know, both counsel to know, all of these proceedings are being recorded, both audio and visual. So we'll upload these to our website, and that will be available. Keep in mind, we have reviewed the briefs, we've conferenced the case, so we're very familiar with it. Try to focus your arguments as best you can in that regard. Mr. Chaifetz.
Thank you and good morning. As this court is aware, the Judge Blomo ruled from the bench, arguably without considering exhibits and without making findings of fact and conclusions of law. Under the law, there's an argument that just the lack of findings of fact and conclusions of law is a basis for reversal, but not necessary for a determination by this court. However, the Miller v. Board of Supervisors of Pinal County, 175 Arizona 296 decision provides that this court, as always, is a normal standard of review when considering legal issues, make a determination of the law. And it's our position that despite the lack of findings of fact, that there are four separate areas in which this court can make a legal determination that it would be appropriate to issue injunctive relief to put Ms. McNally back on the board.
Yeah, I'm sorry. That argument just kind of washed over me there a little bit. I don't mean that in a mean way. I mean that, did you make a Rule 52 request for findings of fact?
No, we did not, Your Honor.
Okay, so the judge wasn't required to do that. The judge wasn't required to make findings of fact. I don't know of any law that says that.
Your Honor, typically the law does not require findings of fact and conclusions of law, but it's my understanding under Rule 52A, and obviously we didn't recognize this at the time either, Your Honor, is that it is a requirement, and the case law does seem to provide that absent findings of fact and conclusions of law, that it puts this court in a difficult position to evaluate whether the facts determinations were appropriate and abuse of discretion, and therefore it's typically reversed and remanded.
No, the judge did make findings. He didn't make express findings in his order, but he made findings in the transcript. That's not sufficient? Is that what you're saying?
Your Honor, I mean, the Miller case was a concern of ours in that we felt that we should have, we had an obligation, with hindsight, that we should have asked for findings of fact and conclusions of law. Certainly the court did make certain findings in the transcript. But whatever the case, whether it's based on the Miller case we've cited or just the normal standard of review, our position is that these are largely legal issues based on uncontested facts, the points that I'm focusing on today. And in addition to asking that the court determine that Ms. McNally should be placed back on, allowed to participate in executive session, that they also should rule that the rampant open meeting violations where they consider in executive session facts that must be considered openly should be addressed as well.
Well, let me ask you a question, just to kind of start out, provoke your thinking a little bit. The board's position is that your client was disclosing confidential information. That's the board's position. I know that you argue it wasn't confidential, it had already been disclosed to non-board members, so forth. But for the sake of argument, let's say it was confidential information or some of it was confidential information. What should the board have done to protect that information apart from this blanket exclusion order? What do you think they should have done?
Well, under the law regarding directors, it suggests that board members are deemed innocent and to have acted in good faith unless established otherwise. So we think it's the burden of the board to establish wrongdoing in some method of due process. And we think the remedy would be pursuing injunctive relief themselves.
Okay, so at the core of what you just said, it's the self-help that they took through their board resolution that you think was one of the major problems here. They should have gone to a court and sought court intervention. That
would have assured my client of due process, and it would have addressed what we believe is the lack of authority for them to exercise self-help. As we've argued, there's simply no legal authority to proceed in such a manner. And so we think that that alone is a standalone reason, just lacking the legal authority to, there's no statute, there's no case law that allows this type of thing, and there's no bylaws, there's no rule. So we think the board simply lacked the authority to take away this type of right, and if they thought that there was such a great risk that they had the right to go to court. This issue was addressed in one of the cases we cited, and it's the one case that's closest to this situation where it doesn't involve the removal of a director. It involves basically limiting the rights of the director, and that's in the Near decision. And in that case, the court said there is risk if we allow this board member to continue, but we don't think it's appropriate to limit this board member's rights. They've been duly elected. Just because there's a perceived risk doesn't mean we can just start limiting their rights. And so, in that case, they ordered, in that case, they were trying to restrict a board member's right to see bank records, saying that the board member had a conflict of interest.
That's that older case?
Yes, 18, very old.
Right.
There's not much law in this area.
Judge Orozco was on that panel for that decision. But moving on, I feel some hostility to my left, your right. Are there circumstances where a board could exclude a board member?
Well,
let me give you an example. Obviously, you have the fiduciary duties that a board member has, self-dealing situations. Sometimes that can even progress into litigation, where board members are suing each other. One might claim they represent the corporation, the others, individual board members. Could you foresee a situation where they might not be able to discuss potential litigation against a board member?
Well, if it is common that if there's litigations, often involving board members, that they're excluded from those discussions. And there's usually not an art.
Do you have to have a court order to do that?
No, you don't. I think it's, I'm just, speaking from experience, I've just seen that many times where obviously somebody's, I think it's a blatant conflict of interest to sit with the board when you're suing the board. So,
well, that's logical. I have no problem with the logic. The problem is it a slippery slope? Because we're suggesting that in that case it's logical to use self-help. But in this case, it's unlawful to use self-help.
Well, we think it's the slippery slope is in the other direction, that if you allow the majority to exercise its will upon the minority, as was discussed in all the cases just dealing with the removal of a director, there's a great opportunity for mischief.
Well, that's a fair point, but it doesn't really answer my question.
Okay,
which is if we acknowledge that there are some circumstances where self-help is possible, such as the clear conflict of interest generated by potential litigation against a single board member, what's our standard for ending self-help?
Well, I think when there's a situation where there's a blatant conflict of interest, and we're talking about a single meeting, we're not talking about a blanket prohibition from participating in executive session or any board functions. We're simply talking about when there's an obvious conflict of interest, when you're on the other side, then I don't even know if self-help is necessary. In my instance, it's in my experience, it's just always been assumed that they can't participate.
Right, but what if that board member says, I'm not leaving? I think, and the example I would give you would be, I think what you're about to discuss regarding me in executive session is illegal, and I have a right to the shareholders, members, to be there to participate in this discussion, and they won't leave. Can a board then, again, resort to self-help and say, we're passing a resolution, you're out of here? Or if it gets to that point, do they need court intervention? Is that your argument?
I think court interventions is always their option, and I think.
Is it required though?
I think so, under those circumstances. I mean, the fact that somebody raises a frivolous argument and says they should be able to participate in discussions regarding the case against them, they're going to lose if they go to court. And if they force the other side to go to court, there's very much a risk of penalties. But I think from a policy standpoint, putting the burden on the other direction and saying they have this ability to resort to self-help and that they get to exercise their judgment without due process creates a significant risk of abuse. As we've seen here and as the cases demonstrated, the tyranny of the majority is often exercised in these type of situations, and ultimately the real person that loses is the elected.
Where's the legal line between what's obvious and assumed and the tyranny of the majority? Somewhere along there, your argument is that on the obvious and assumed side, it's fine to use self-help, and if we go too far, we get the tyranny of the majority. So where's the legal line that tells board members when they can't use self-help?
And let me just dovetail off that question. When, if ever, can a board exclude a board member from an executive session without a court order?
Well, this raises other issues too, because it's more than just they've passed a resolution. The board member can still show up, and then they're going to call the police, and you get into these type of issues where oftentimes self-help requires court intervention to avoid conflict. So, but as far as
court intervention is not self-help. Court intervention means you go ask the court for an order, the court resolves the question. We have talked about a situation where I think everyone would agree it's fine to kick the board member out, right? When there's an obvious conflict of interest.
I've seen it exercised. I think as a matter of policy, if you have to go one direction or the other, I think it's much better to not allow that board that right, because it's so subject to abuse. If the board can simply, in its own discretion and without due process, make a determination that we can now exclude this board and basically this member, limit his power. And that's really what these are, is power struggles. And if you allow them to have the power to simply limit the rights of a board member at their whim, because I really think we're looking, I assume that's what this court's looking at, is these type of policy considerations. And if you're going to have to draw a bright line, I would think it would have to be on the side that they simply do not have the authority to limit the powers of duly elected board members.
There's an argument that's raised by Applee. They claim that they created a subcommittee to deal with, and I'll have to ask counsel about this when you come up here. Indeed, I will. But
You'll forget.
No, I won't forget. Could they have created a litigation subcommittee to deal with the whole Martin's email potential litigation, probably recused all of themselves from it and created that separate committee? Do you think that there's that authority? And I ask that because I've seen that. I know in corporate situations, sometimes they'll do that, where the board members are at least involved in litigation. They'll create a litigation subcommittee to make decisions for the corporation to decide how to handle the litigation.
I think that would have been appropriate here if they were all not participating and it wasn't a power struggle and it was rather an effort to get to the bottom of the truth. I think that's what committees are for, is to allow separate investigations or different policies or whatever procedures there.
Would you have ultimately, though, required court intervention to create that litigation subcommittee?
No, it's allowed by statute. And but I think it's important for this court to note.
Hold on, though. Doesn't that statute require court action? I know the statute you're talking about. Can a board do that without a court order?
Yes. My understanding is that it provides that they can form committees, but there's no evidence that a committee was ever formed.
Okay.
I mean, they never formed a committee. And again, from a policy consideration, if you allow them to form committees to limit the rights of fellow directors, if that's truly their intent, then it's the same type of abuse of just ordering that they can't participate in executive session. I mean, there's an intent of the legislature in allowing these committees was to do investigations, not to limit the power of board members. If every executive session now is claimed to be a committee meeting, that's really just a pretext to exclude somebody from executive session. And again, I would think it's improper.
Like for shareholders' derivative lawsuits, it does require court action to create a independent panel to review on behalf of the corporation any alleged wrongdoing. I guess what I'm getting at is, your point is, you can't just create some committee to bootstrap an exclusion order into the creation of the committee and say that committee is now going to consider executive privilege matters.
I mean, you could use it, if that type of abuse was allowed, I mean, they could create committees for everything they wish to just prevent certain board members from participating in.
So, I mean, it seems like most of the vehicles at least in the corporate statute, require a court to approve or order that. But
I think a committee they can form, but I think if it's used for improper purposes to take away power from a board member, then I think it would be improper use of it. But again, just to remind the court, there was no committee. There's no evidence they ever formed a committee. I think it's an after-the-fact effort to justify what's unjustifiable. But to continue, Your Honor, so I think we've argued there's no authority. We've argued due process. We challenged whether there was ever a violation in the first place. It was, in effect, a public email read at a public meeting. And I think it's important for this court to consider that this is really a form of political speech involving a quasi-government. And it's this type of, I'm not suggesting the First Amendment directly applies, but I think the same policy considerations should be considered because, in effect, we have...
Counsel, I don't think you raised anything about that in your brief.
I did not.
Okay. We're going to go off on some First Amendment. I'm not really...
Well, I just think it's important to consider that this is really just board members. The purpose of the First Amendment is oftentimes you don't want somebody to exercise political speech, and that's why it's so important to protect it.
Yeah, I think we would analyze this very differently if we were looking at this as a First Amendment free speech case. Now, I know that you want us to get to the open meetings law issue.
Yes.
Why can't you just raise that in the trial court now? I mean, when the judge decided not to take up that open meetings law issue, basically Judge Blomo said, Bloom, is it?
Well,
Blomo, okay. Well, I'm right for a change. He said, you didn't argue that in your application. I'm going to just take up the order compelling participation in the executive session meetings. I know he could have gone either way. He chose not to go in the direction you wanted, but he didn't deny a request for a preliminary injunction on compliance with the open meeting law. What stopped your client from going in there and filing an application on those grounds?
Nothing, Your Honor. I think we could have raised that issue. I think we've been dealing with the limited resources and trying to address these issues.
The other question I had about that was, I think I agree with you that the open meetings issue is at the heart of this. Is it possible the trial judge decided not to take that issue up because this issue of participating in the executive sessions was more of a discrete issue he could decide in a limited hearing? Or once you get into the open meetings issue, that's really at the center of the whole case, all the damage claims, everything, right?
Well, we think it's directly related. I mean, part of our, the defense was arguing that there was no harm to our client, and basically what we've said is they're, in effect, making decisions in these executive sessions that our client can't participate in, so we're suffering great harm. And so that is why it was allowed into evidence, and we think once it's brought into evidence and we demonstrate that there's open meeting violations, the purpose of an injunction is to formulate a remedy to bring about justice, and, we don't see how a court can hear violations and ignore them. Obviously, there's other means by which we can address that, and we can still do so. But we think when the court has that information provided to him, habitual violations, that the court should act upon it. And then, so I've talked about due process, I've talked about no authority, we've challenged whether there was a violation in the first place, and then finally there's the penalty, which, our client was initially penalized to the end of her term, 6 months. Our client waited till the end of her term, did choose to run for re-election, was re-elected, and then they arbitrarily add an additional 3 years.
Is your client term limited out now at the end of this term in February 2017?
Yes. I mean, we've considered trying to address that issue because we think it's unreasonable that she be excluded and then termed out. But yes, that is the case. And
she has to skip one term and then she can run again? Is that what it is?
I believe that's the case, yes.
So she'd have to wait, what, a year? Or
3 years. Okay. So, Your Honor, we believe that the legal questions on these issues are clear and succinct, that the court can, as a matter of law, determine that there was no authority to do what they did, that they had a requirement to offer some form of due process, that there was no violation, and we know the violation issue would typically turn on facts, but there's really no dispute as to where this email originated and how it was disseminated. I mean, it was read publicly, and it's a public email. And even if it upsets people, it doesn't give them a right to limit our client's power. And clearly, the means by which this penalty was imposed and arbitrarily extending it after they already issued an earlier penalty was improper. And to a large extent, this has all been based upon the belief of the trial court and our opponents that somehow our client was obligated to take a pledge that she would not discuss what was discussed in executive session. And she's always indicated she would follow the law, but she wants to do just that. And when the association is violating the law by addressing things in executive session that are improper, she should not be required to keep quiet and not disclose that and be forced to participate in that wrongdoing. And that's really what we think was at issue here. I'll reserve my 8 seconds.
Thank you, counsel.
Thank you.
Is it Ms. Samuelson?
Yes. Good morning. May it please the court. My name is Stephanie Samuelson, and I represent the appellee Sun Lakes Homeowners Association. I'd like to start off by addressing some of the issues that the court raised and that opposing counsel raised, and that is, first of all, Judge Blomo clearly had findings of fact. They may have been in his transcript, but they're there. I think the most paramount one is the one that he concluded that Director McNally could not keep what was stated during executive sessions confidential. That was his finding of fact that he
His finding was
raised.
actually she would not. She
Exactly.
said she would not.
Yes, I'm sorry, Your Honor. And you're also right, Your Honor, there was no Rule 52A request. There's also nothing in the law that says that a director is entitled to be a part of every executive session meeting or that a director is entitled to make all decisions on behalf of a board.
Just, if I may.
Sure.
When I picked up this case and I first looked at it, the very first question that arose in my mind is, what is the authority for the board to issue a blanket resolution that prohibits a board member from ever attending another executive session again? And I can't find anything that allows a board to do that, a HOA board, any type of board. I mean, the very essence of a director's duties and responsibilities are to participate in board meetings, and a lot of things happen in executive session. And I just...
Sometimes more than should.
That's right. I don't see anything in the bylaws. I don't see anything under the HOA statutes, anything under the corporate statutes, nothing. I don't see a case. I recognize that there's some case law out there that says a director is not entitled to all confidential information. They're not entitled to every record in a corporation. There's cases out there where directors have requested to look at certain records, and the court has ordered that they be precluded from doing that. I recognize that. But what you're talking about here is precluding in a blanket fashion a board member from ever attending any executive sessions. And Ms. Samuelson, I have to tell you, I can't find a shred of authority for something like that.
Well, I think there is authority.
Without a court order?
Sure.
Okay.
10-3825, which you addressed earlier, does allow a board of directors to form a committee to address any issue that the board of directors can address, with limited exceptions that are not applicable here. So the board of directors could have formed a committee to address executive session materials and could have voted to exclude her, which I think is exactly what they did here. As we talked about at the trial court level, they didn't do it artfully. They didn't do it specifically underneath the statute, thereby saying, we're going to form a committee under ARS 10-3825. But that's, in effect, what they did.
Counsel, I mean, I read the statute, and I understand that under that 10-3825, a board can delegate certain duties. They can delegate duties and responsibilities they have as a board member to these committees. They can create these committees. Setting aside for now the issue of whether such a committee was ever created, do you believe that statute allows a board to simply create a committee to consider executive privilege matters and completely exclude a duly elected board member from ever participating in another executive session again? Is that how you read that statute?
I think it can, Your Honor, as long as it's not one of the issues that's precluded from being discussed underneath the
Let's say
statute.
we have a 7-member board, and we happen to have 4 who generally agree with one another and 3 who generally are the dissenters. Can the 4 members simply say, we're creating a board committee comprised of us to deal with all matters that might be of interest to our corporation? And that committee doesn't, surprise, surprise, include the dissenters.
If they follow what the statute requires as far as forming a committee, and I do
I'm
not
looking
recall.
at the statute now. It doesn't require much.
Okay, yeah.
It just requires the formation of the committee. So that would be a convenient way to eliminate all dissent. As long as the majority can simply call themselves a committee, they don't have those pesky other board members. I don't think that's what the statute was designed to accomplish.
Well, I'm not sure that that's what the statute was designed to accomplish, but I believe that the statute does allow that. And I think it's, as of right now, I think it's the public policy of the state that is reflected in that statute.
Public
that they
policy
can.
of the state, surely, I'm aware of no statement of public policy in this state that says dissenters' rights can be squelched simply by the formation of a committee. We would never have dissent.
I agree, Your Honor, but I do believe that it is.
I want to be even more specific.
I'd like to hear the answer, though.
Okay, but I do believe that it's the obligation of the board to protect the association. This board is charged with making sure that the board is protected, and Director McNally
Well, the majority always thinks it's in their right. That doesn't persuade anybody.
The fact of the matter is, this Director
Let me just
McNally
answer one of your questions. You asked a second question.
has subjected this board to liability in the past, and she just went completely against what the board decided, what legal counsel advised the board. She completely disregarded that.
I understand the majority thinks it has the reasons to do what it did, but those may give the majority grounds to sue her for damages. They may give the board grounds to sue her for exclusion pursuant to a court order. But the idea that 3825 authorizes board members who merely think they're in the right to exclude from the performance of their duties minority board members strikes me as an argument for a sea change in corporate law. And if I'm missing something in your answer, I'd like to know. But I think you said that the 3825 does allow the majority to simply exclude the minority always by committee.
Well, I think that the statute allows them to do what it allows them to do. As of right now, it allows them to form committees to address any issue that is not specifically not allowed in the statute. And as of right now, that's what the statute states. Now, I don't think we're operating in a vacuum in this case. We have ARS 10-3830 that specifically tells us what a director's obligations are.
Counsel, I now have Judge Swan's permission to ask my next question.
Okay.
Thank you.
I know you haven't gotten much of a chance.
No. Okay. Ms. Samuelson, the statute 103825, it has to be construed with the other statutes in that statutory scheme. That's a fundamental
Yes.
principle of construction. And in the same statutory scheme, it lays out the duties and responsibilities of directors. They shall participate in managing the affairs of a corporation or homeowners association. Now, we have to read those and harmonize those two. If I read 3825 the way you're describing it, I would have to essentially read out the statute regarding their duties and responsibilities. And that's a mandatory responsibility. When you're elected as a director for an HOA, you shall participate in managing the affairs. Construing those two statutes together, I don't see how your construction can be a valid one.
Well, I think you also have to look at 10-3830, which sets forth the duties of the directors. And when a director is completely going against what the duties of a director are, the objective requirement underneath that statute. You know, there's 3 requirements that a director must do when they're acting. They must act in good faith. That's the subjective standard. They must act as an ordinarily prudent person would in a similar position under like circumstances. That's an objective standard. And that's the part that she's failing here.
And what you're I understand your argument. You're saying that she has fiduciary duties to the association.
Absolutely. And the other board members have fiduciary duties, Your Honor.
Isn't the remedy there to go to court? Because Ms. McNally's not going to recuse herself from these meetings. There's obviously provision for that under the statute. She could recuse herself. She's not going to. So isn't the remedy to go to court and get an injunction precluding her from disclosing confidential information in the corporation, or get a court order excluding her from any executive sessions discussing the Martin's email, rather than a blanket resolution with no court intervention saying you can't ever go to another executive session again?
I think that is a remedy. I don't think it's the only remedy. And I don't think the statute states that that's the only remedy available to the association.
One of the remedies in the open meetings law is removal from office.
Correct.
So if you can achieve that de facto without going through the statutory process or the judicial process, what's the point of including that in the statute?
I don't think we achieved that de facto. She's still a part of the board of directors. She may not sit in for specific things that are discussed under ARS 33-1804, but other than that, she's a member of the board of directors, and she's making decisions on behalf of the board, and she's entitled, as she's even testified at trial and in her deposition, it's actually made her more effective because she has to ask questions when it's the open meeting time. She has to be more forward-thinking. So I think that it's not a de facto.
A little far to suggest that you've done her a favor. I'm not sure.
Well, I'm not suggesting that. She said that.
Well,
I'm not suggesting that.
But the idea is, I think that each board member is equally entitled to the information available to the board.
You're right, Your Honor, and I want to raise a point, too. You know, this initially was only for a period of 5 months where they removed her. Then she was reelected, and the board of directors, the association's council, came to her and said, we want to let you back in. We're willing to let you back in. Can you agree to keep what's stated during executive sessions confidential? And she said no.
That's not what she contends. And I don't know the facts. Ms. Samuelson, I'm not arguing, but
Correct.
She sort of portrays it as the board giving her an offer she couldn't refuse. I mean, you come back and you admit all wrongdoing and that you violated. That's how she characterizes it. Now, at this point, I don't know whether that's accurate or not.
Well, our client contends that that is not accurate, and I will say that the trial court obviously found that that was not accurate, and the findings of fact are clearly erroneous standard. So I don't think that
I don't recall. I read that transcript. I don't recall the board making any finding about whether the offer was, a good faith offer or not. What I recall the board saying was, Ms. McNally, it was the court's conclusion. She refused to keep confidential information. She was not going to respect confidentiality or executive privilege. I do remember that finding.
Yeah, and the court actually asked her that. The court itself, Judge Blomo, asked her, on the record.
Assume that finding's correct. I mean, isn't the remedy then a judicial one under the law?
I don't think so. I don't think there's anything in the statutory scheme that requires us to take action to have her removed. We were trying to achieve a middle ground to allow her to continue on the board without the time, the expense, and all of that to the association and its members in order to have her removed from the association. And frankly, she already did this in the past. She did this, the record reflects that she did this in 2010. She was removed from the board once, and then she got back on and continued to do it again. At that point, there was a provision of the bylaws, I believe it was, that allowed the board members to remove another director. That has since been changed. So the board of directors cannot alone do that. It would require the association members to remove her.
It's a recall election now, right?
Yes, correct.
Go ahead.
You look like you have another question, Your Honor. No.
No.
Okay.
I could ask one, but I think I'd rather hear what else is on your agenda.
Opposing counsel also discussed this as a power struggle. I don't think that this is a power struggle. I think this is the association trying to protect its members and its interests. And the whole problem initially with this was that this was an email written by a former employee, somebody who had just quit her employment, about 2 current employees where she's stating and alleging that they engaged in wrongdoing.
That's not an uncommon fact pattern.
Absolutely not, Your Honor. But I think it's entitled to protection. And I think that once that email became part of the board's, came to the board had an obligation to decide how it was going to handle the issue. And the fact that it interviewed the 2 employees and the 2 employees denied the allegations, the association's president at the time spoke with counsel, and legal counsel said, if, as these employees are telling you, the accusations in the email are false, and you go ahead and you disseminate that information further, it could result in liability to the association. So the association was trying to protect itself. Director McNally went directly against all that. She just felt like it was within her right and her power to disseminate the information. We don't believe that it was, Your Honor. We believe that the trial court was perfectly within reason and logical thinking in concluding that her likelihood of success on the merits, she could not meet that standard for a preliminary injunction.
Well, let's say that this was happening in a more abstractly, genteel way. And so the board takes a vote based on advice of counsel not to take action based on the email. All right. And our appellant dissents and wishes to express publicly the reason for her dissent. Doesn't she have the right to do that as a voting member in a vote that must, under the law, take place in open session?
I believe she probably could do that, Your Honor, but I don't think that reiterating statements that are false or that she has no firsthand knowledge about whether they're true or false in a public forum as a director of the association.
I think a lot of people conducting public debate accuse one another of basing their views on falsehood. That's not grounds for de facto removal or exclusion. If it were, we would live in utter chaos. There is no single agreed upon truth in life, and when people have a disagreement and wish to express the basis for that disagreement, don't they have the right to do so?
I don't think you do. When you're representing a corporation like this and you're potentially subjecting the corporation to liability, the board's made a decision to act one way. You have the recommendation of legal counsel to do one way.
Your clients may just have subjected the board to liability today, right? I mean, they don't know how this case is going to come out. They have taken action.
We have not taken action. She took action.
Well, your
right?
clients excluded.
We're not seeking liability against her.
Your clients excluded Ms. McNally from certain portions of board proceedings, and there is now a legal dispute over whether they were entitled to do so. The association has been sued as a result. Now, how is that any different?
I think it's very different. We didn't.
Because you think your clients are right.
Absolutely.
But the fact is, there's a lawsuit that resulted from their conduct. And now you're here defending their right to do it. Isn't that the sort of the safe zone, if you will, for people to express the reasons for their votes on a board? They may get sued, but that's not a reason not to make the decision.
But there's all kinds of things that boards sometimes have to keep confidential, have to keep within the board of directors. There may be decisions underneath, in this instance, ARS 33-1804, that the board has chose to keep confidential for various reasons. And a director on the board of directors has to abide by that. That's what the law is saying. If she doesn't want to keep this confidential, then she should remove herself from the board.
Counsel,
frankly,
I recognize what you're saying. I understand that from your client's standpoint, they had advice of legal counsel. They feared there would be some litigation, potential litigation over this. And given that set of facts, I don't disagree. in a general sense that a board could discuss that in executive session, then a board wouldn't want a board member discussing what was talked about in executive session regarding potential litigation. I understand what you're saying.
Right.
But the mechanism, the remedy that your clients chose, I'm not aware of any authority that supports just a total and complete ban from ever participating in any executive sessions again. I think there might have been some narrower remedies that your client could have sought to protect that.
Your Honor, I don't disagree that there are potential other remedies that my client could have sought, but there is nothing in the law that states that they cannot do what they did. Nothing under the Arizona statutes, nothing under the nonprofit corporation statutes, nothing under the homeowners association statutes. The association had a duty, these other board of directors had a duty to protect the association. They did what they thought was the best thing to do. They did what legal counsel was advising them to do. We believe that Director McNally's likelihood of success on the merits is not likely. And if the court has nothing further, I will conclude since I'm near the end of my time. No.
Thank you, counsel.
Thank you, counsel.
Did you want some additional time? I can give you a minute if you want. I don't know what you can say in 6 seconds.
Well, maybe 10. Your Honor.
Hold on. Just add 1 minute. Is that okay, Ms. Samuelson? Absolutely. Okay.
Thank you. Charlie Maxwell was the attorney that originally blessed this procedure. Very influential attorney in the homeowners association field. Scott Carpenter testified as an expert over our objection at the trial and blessed this procedure. Both these, Scott Carpenter's firm is arguably the largest HOA firm in the nation. The fact that they would bless this procedure, we think, is because of the legal vacuum that exists over the issues over whether they had authority and was there an obligation for due process and things of that nature. We would welcome a published opinion that would clarify the law, that would make it more difficult for this type of thing to occur in the future.
Thank you, counsel. We'll take this matter under advisement and we'll issue a written decision. Court's in recess.